Thank you for watching this webinar on special education dispute resolution. My name is Stephanie Klitsch, and I am the Assistant Director of the Education Law Program at Council for Children's Rights. Just a note that the information I am providing today is for educational purposes and is not legal advice. Before I jump into the content for this webinar, I wanted to share a little information about the Education Law Program. The Education Law Program has four main focuses. First, through our Education Advocacy for Individual Family Service, we provide individual representation for students and their legal guardians in need of legal assistance regarding education matters, such as special education, Section 504 plans, school discipline, enrollment, and bullying. Second, through our Education Navigation Service, we work with students involved in the juvenile court system in Mecklenburg County. The service addresses issues related to students' education rights by identifying current education issues and providing detailed recommendations for how to resolve those concerns. Third, we focus on systemic education issues. We cannot individually serve all students in our community who may need our services. Instead, we strategically elevate issues that can have a broader impact on students in the community. Lastly, we provide free community trainings on topics related to education advocacy. In addition to our First Wednesday series, we provide training to parent groups and community groups by request. The contact information for each of our programs is on the slide. Here's the agenda for this webinar. I'll go over some preliminary information and then focus on our main topic, special education dispute resolution. First, I'll go through 3 quick notes. Then I'll give an overview of the different types of education interventions. I'll move then briefly to reviewing the fundamental concepts of the Individuals with Disabilities Education Act, or IDEA. After, I'll discuss the main avenues for dispute resolution, including IEP meetings, independent educational evaluations, facilitated IEP meetings, dispute resolution consultants, mediation, state complaints, and due process hearings. I'll finish with a hypothetical situation. Before I get started, I want to go over a few terms that I will use throughout the presentation. There are many acronyms when we discuss special education and some different terms that mean the same thing. I want you to understand that students who receive special education have an Individualized Education Program, an IEP. They are also called exceptional children, EC. EC is a North Carolina specific term. Ultimately, when we are talking about EC services, IEP services, or special education, we're talking about the same services and can use these terms interchangeably. The Special Education Decision Maker, or SEDM, is a term you'll hear me use throughout this presentation. I'm going to use it instead of the term parent when discussing special education services, and let me explain why. SEDM is an umbrella term that incorporates all of the different individuals that might be making the special education decisions for a student. For the majority of students, it is their biological or adopted parents. For others, though, it is more complicated. For students that live with non-parent legal guardians or are in the foster care system, the SEDM might not be their parent. Other options include non-therapeutic foster parents, guardians, kinship placements, local educational agency or LEA assigned surrogate parents, or court-appointed special education decision makers. SEDM is the person legally acting as the student's parent for purposes of special education decisions. This is the individual who requests an EC evaluation, consents to EC services, and has the right to pursue dispute resolution strategies. So while for most students, their SEDM will be their parent, we're going to use the term SEDM to be inclusive of all possible individuals who might be making special education decisions on behalf of students. This term does not apply when we are discussing Section 504 plans. When referring to Section 504, I will use the terms parent/legal guardian. Some families choose to send their students to charter schools instead of a typical public school district. Charter schools are public schools authorized by the State Board of Education and operated by independent nonprofit boards of directors. Everything that I will discuss in this webinar applies to charter schools as well as traditional public school districts. Charter schools must follow special education law, Section 504 law, and North Carolina law on school discipline. Too often, we learn of situations where charter schools are telling families that they do not need to comply with these laws. So we want to make it clear that students have the same rights in charter schools as they do in traditional public school districts. Next, I'm going to do a brief overview of the different types of education interventions. We like to begin trainings with these slides so that everyone is aware of what we mean when we talk about terms like IEP and Section 504 plan. This graphic helps us take a step back and understand what types of services are available to different groups of students. The largest circle incorporates all students, whether or not they have a disability. A student who is struggling academically or behaviorally in school can receive extra assistance. In North Carolina, this is through something called Multi-Tiered System of Support, MTSS. A student does not need a disability in order to receive support through MTSS. In order to fall into either of the two smaller circles, a student must have a qualifying disability. The bigger of the two circles is Section 504. As we will learn, more students with disabilities fall under Section 504 than under special education. Special education is the smallest circle because it has the most stringent eligibility requirements. As I mentioned, MTSS is available to any student, whether or not they have a disability. It is intended to provide extra support and interventions to students with additional needs. MTSS involves different tiers of support. All students are considered on Tier 1 and have access to high quality instruction. At Tier 2, students with identified academic or behavioral needs receive some small group intervention. Tier 3 is the highest tier of MTSS. At this tier, students receive more intensive individualized supports. A key component of MTSS is universal screening. This is intended to identify students who need supplemental support. By the time students get to Tier 3, they should be receiving evidence-based interventions to respond to their specific needs. Progress monitoring is a part of MTSS as well. This means that there are specific goals that the interventions are intended to address, and data is regularly collected to determine whether students are making progress towards those goals. Families need to be aware when their student is on a Tier 2 or Tier 3 plan and actively participate in the process. There are generally meetings to review the student's progress, and the family should attend and ask to get regular updates based on the progress monitoring. The MTSS team can make a referral to special education if they believe that the student may qualify for an IEP. This referral can happen concurrent at the same time with MTSS interventions and need not wait until those interventions have been exhausted. Let's talk briefly now about who qualifies for special education services, which was the smallest circle in that first graphic. For a student to receive special education services, the student must meet all of the following criteria: be between the ages of 3 and 21, meet the criteria for at least one of 14 disability eligibility categories. In North Carolina, each disability eligibility category has specific requirements that must be shown for the student to fall under that category. For instance, a diagnosis of autism by itself does not necessarily mean that a student will automatically be eligible under the autism eligibility category. They also have to have a disability that adversely affects their educational performance and requires specially designed instruction. I want to point out that educational performance is broader than academic performance. A student can be advancing from grade to grade and have passing scores in their classes and still be eligible. Educational performance also includes things like their social interactions and behavioral needs. Here's a list of all 14 disability eligibility categories in North Carolina. IEP, as I've said, stands for Individualized Education Program. The P in IEP stands for program and not plan. And that is because an IEP incorporates all of the special education services that a student receives. The IEP document itself is long, generally at least 15 pages, and is very detailed. Included in the IEP document are the student's strengths, weaknesses, and needs, measurable goals for the student to achieve in the course of a year, the accommodations and modifications, related services, and specially designed instruction necessary to help the student reach their goals, and where the services will be provided. This does not mean the actual location, such as Myers Park High School versus West Charlotte High School. Instead, this refers to whether the student will receive the services with their non-disabled peers, or instead in a setting with only other students with disabilities. For many students, it ends up being a combination of those options. The IEP document is developed by an IEP team, which must include the special education decision maker. All special education students are entitled to something called a free appropriate public education, FAPE. A FAPE is a legal standard that requires all students' IEPs to be sufficient for the student to achieve reasonable educational progress. I often receive questions about the difference between IEPs and Section 504 plans. As I have said, all students who receive special education services have an IEP. Students with IEPs receive some amount of specially designed instruction with a special education teacher. Specially designed instruction is adapting the content, methodology, and/or delivery of instruction to meet the unique needs of a student that results from the student's disability. Section 504 accommodation plans, however, are for students with disabilities whose needs do not rise to the level of requiring specially designed instruction from a special education teacher. These students receive all of their instruction in a general education environment. They receive accommodations and modifications that their general education teacher can implement to allow the student to have access to their education. Also, Section 504 has a broader definition of disability, so more students qualify under Section 504 than qualify for special education. This is why the Section 504 circle in the first graphic was bigger than the special education circle. If a student has an IEP, they do not require a Section 504 plan, because everything that would be on the Section 504 plan would be incorporated into the IEP. Hopefully, an example will help illustrate the difference between an IEP and a Section 504 plan. Sam meets eligibility criteria as a student with a specific learning disability. His IEP provides services with a special education teacher several times a week to address his individual goals in reading, writing, math, and organization. He also receives modified assignments, extended time on tests, and takes tests in a room with fewer students. On the other hand, Erin has severe myopia, which is nearsightedness. Her Section 504 plan requires seating near the teacher and board, and all printed materials to be presented in a larger font. As you can see, Erin does not have any special education services or any individual goals like Sam has. Also, Sam receives accommodations and modifications that, if those were all he needed, could be on a Section 504 plan. Those accommodations and modifications are modified assignments, extended time on tests, and taking tests in a separate setting. Here are some important similarities between IEPs and Section 504 plans. They both generally have review meetings every year. IEPs are required to be reviewed annually. And while that requirement is not in the law for Section 504 plans, it is a common practice for them to be reviewed annually as well. These are very important meetings for families to attend. While there's only one meeting required each year, families can request IEP meeting or a Section 504 meeting at any time during the school year. Lastly, IEP teams and Section 504 teams can spend hours and hours drafting a beautiful document, but if it's not actually implemented, then functionally it's worthless. It is critical for families to follow up with teachers to make sure that the services, accommodations, and modifications are actually being provided as written. Before I jump into discussing the different types of dispute resolution avenues, I wanted to briefly review some of the fundamental concepts under special education. The Individuals with Disabilities Education Act, known as IDEA, is the federal law governing special education. It was originally passed under another name in 1975 and has been reauthorized several times. Under IDEA, each state gets some federal money to help provide special education to students with disabilities. In exchange for the money, schools must follow the requirements of IDEA. We are going to review some of the most important concepts under IDEA. Disagreement between families and schools often center around disputes about the meaning of these concepts. IDEA guarantees a free, appropriate public education, a FAPE, in the least restrictive environment, the LRE. These are necessarily subjective standards designed to lead to tailored solutions that address each student's unique needs. But as you can imagine, that also creates some gray area that gives rise to disagreement. What actually is appropriate, or what actually is the least restrictive? We will review these terms in more detail now. Let's talk about FAPE a little bit more. FAPE means special education and related services that are free, appropriate, and public. First off, free means free. The SEDM does not pay for any services, nor are there any administrative fees that can pose a barrier to services. Appropriate is where you might see the most tension. The word appropriate in FAPE has been interpreted by the Supreme Court of the United States. The Supreme Court has not interpreted appropriate to mean that the school has to make the student the best student they can possibly be. There have been two Supreme Court cases to interpret this term. One was Rowley in 1982, which established appropriate as meaning that the student must make reasonable educational progress to receive a FAPE. The other case was Andrew F. in 2017. In Andrew F., the court said that a student's special education program must be appropriately ambitious in light of the student's circumstances. This is determined by the student's own circumstances, not the school's circumstances. We don't have resources is not a valid basis for a denial of services. It is important for SEDMs and advocates to understand when in an IEP meeting, not to state that you are requesting services for the student because you think the student needs them to do the best they can or to maximize potential. The school staff know that this is not what is required, and therefore they won't be moved to action by that. Instead, the SEDM should be making the case for what the student needs to make reasonable educational progress that is appropriately ambitious for them. Public education means that the services are supervised and directed by the local school system. As I've said, special education is specially designed instruction provided at no cost to SEDMs, and that meets the unique needs of the student. Specially designed instruction means adapting the content, methodology, and/or delivery of instruction. The unique needs of the student go beyond just academics, however, and may include social, emotional, physical, health, and vocational needs as well. Take, for instance, a student with a severe cognitive disability. Their specially designed instruction may include a focus on activities of daily living and social interactions, in addition to more traditional academic skills. Related services are those additional services necessary for a student to benefit from their special education. A very basic example is a student with some measure of hearing loss. If they cannot hear their specially designed instruction, they cannot feasibly benefit from it. So audiology services may be included as a related service and provide, among other things, a check-in once or twice a semester with the school audiologist to make sure their hearing device is working as intended. I've listed other common related services on the slide. The last of these big concepts I will cover is a least restrictive environment, LRE. LRE means that students with disabilities shall be educated with students without disabilities to the maximum extent appropriate. This means that students will be placed somewhere along a continuum of placement options according to their unique needs. Consultation services are the least restrictive, in which the special education teacher collaborates with the general education teacher on the student's instruction. But the special education teacher provides minimal, if any, direct instruction to the student. Inclusion classes, sometimes called co-taught classes, are classrooms where the general education teacher and a special education teacher work together to support the students with special education needs. The students remain in the general education setting, but receive support on their IEP goals from the special education teacher in the room. With resource or pull-out services, students are removed from their peers without disabilities and receive instruction in a separate classroom for some portion of the school day. In separate classes, students spend the majority of their day apart from their peers without disabilities, though they remain in the same school and are able to interact with the whole of the student body through other shared activities. Students in separate classes often still attend elective classes with their non-disabled peers. Separate schools are exactly what they sound like. A student's needs are significant enough to warrant placement in a more specialized school setting, wholly apart from their non-disabled peers. Lastly, we have home hospital instruction, the most restrictive, wherein the school provides one-on-one instruction directly to the student in their place of residence. This is supposed to be a temporary placement, and minimal hours of instruction are provided. Remember, placement anywhere along this continuum outside of the general education setting requires justification grounded in the student's individual needs. Other reasons, like availability of placement or administrative convenience, are not valid justifications. I will transition now to our topic for today, special education dispute resolution. Listed on the slide are the different dispute resolution avenues we will cover. If an SEDM is considering an option beyond an IEP meeting, the SEDM may want to consider involving additional support, such as a special education attorney or advocate. As a note as we get started, there are a lot of different possible disputes that can arise in special education. Each situation requires an individual analysis to determine which strategy or strategies may be best. This training will give you a sense of what each strategy involves. When determining which strategy is best, SEDM should think carefully about their desired outcomes. The law does not allow for money damages, meaning SEDMs cannot get money to compensate for the failure of the school district to provide a FAPE. You may be surprised that we list an IEP meeting as a dispute resolution strategy, but it is an important one. Unless there's just been an IEP meeting on the very disagreement at issue, it makes sense for the SEDM to request an IEP meeting to discuss the concerns for a few reasons. First, it is always ideal if situations can be resolved at this level. It's often quicker than formal dispute resolution avenues and can maintain relationships with school staff, which is important if the student will likely remain at the school. Second, it can help clarify the nature of the disagreement. And third, it gives the SEDM a chance to have the disagreement clearly stated on the prior written notice. The prior written notice is the IEP form completed at the conclusion of an IEP meeting. It provides a summary of the meeting. It is required to state what the IEP team agreed to, what was considered and rejected by the IEP team, and what was proposed by the SEDM and refused by the school team members. There is a distinction here between proposals that were rejected by the IEP team and proposals that were refused by the IEP team. A rejection is for an idea that the team discussed, but generally agreed was not needed or appropriate. For instance, let's say that the IEP team discussed whether the student needed extended time on tests, but then determined that the student never uses all the testing time she's given. This would be something that the IEP team proposed and then rejected. The refusal section is really reserved for items that the SEDM proposed, but were not agreed to by the IEP team. Having the disagreement clear on the prior written notice will be useful in any additional dispute resolution strategies an SEDM wants to pursue. An SEDM can request that someone with more experience from the EC department attend the meeting. At the school level, there is the compliance facilitator. There are also district level EC staff who may be able to attend. In Charlotte-Mecklenburg schools, CMS, those staff are called EC Learning Community Coordinators or Itinerant Coordinating Teachers or ICTs. An SEDM cannot dictate which school members attend an IEP meeting, but it is in everyone's interest for the dispute to be resolved, so they may send someone if you request it. We have regularly found that having someone from the district's EC department at the meeting can help resolve issues. They tend to be more knowledgeable about the law and procedures and may have ideas for how to resolve the dispute. We have a separate training that covers in great detail how to prepare for an IEP meeting, but we wanted to briefly review some of those concepts now. Preparation for an IEP meeting takes time. These are steps you should take in the weeks leading up to the IEP meeting. In preparing for the meeting, you want to review any relevant documents. If you do not have the records listed on the slide, you should request them from the school. A really helpful strategy is to request a draft of the proposed IEP in advance of the meeting. That way, you can compare the student's current IEP with what the school is proposing. If you're seeing it instead for the first time in the IEP meeting itself, it's challenging to understand what is being changed. Often it is helpful to bring some people with you to the IEP meeting. This may include people like the student's tutor or a therapist. For professionals who may not be able to attend in person, you could ask them to participate in a portion of the meeting by phone or to provide their recommendations in writing to the IEP team. Early on in IEP meetings, SEDMs are asked to provide their current concerns for the student's education and their vision for the student's future. Especially if there's a potential dispute, it's helpful to draft your concerns in advance. Be honest and thorough. You can email your concerns to the EC case manager before the meeting to copy and paste directly into the document. If the student will be attending the IEP meeting, be sure that this is not the first time they are hearing your concerns. You want them to be prepared for the IEP meeting as well. For the vision statement, be modestly aspirational. Don't sell your student short, but also don't burden them with unrealistic expectations. It is important for students to share their own vision for their future. Be sure to talk to them about it in advance of the meeting. Before the meeting, think about your desired goals. Make a list of questions you have for the IEP team and brainstorm some suggestions or interventions that may help the student. Detailed preparation should help you feel prepared for active participation in the IEP meeting itself. For SEDMs, these meetings can often feel hurried. Do not be afraid to stop the flow to ask questions and get clarification. It is critical that you understand what is being said, and if you do not, the school staff needs to explain it to you. Throughout the meeting, do your best to be kind and respectful, even in the face of disagreement. Pay close attention to what is written on the prior written notice IEP form that I discussed earlier. Usually, prior written notice forms are reviewed at the end of the IEP meeting. So try to keep notes throughout the IEP meeting of the items you want documented on the form. Make sure that all disagreements that arose during the meeting are clearly written on the floor. If you ask for something that your student and the school said that they could or would not do that, your request should be written as a refusal on the form with an explanation of why it was refused. If something was agreed to in the meeting, but was not written anywhere in the IEP or prior written notice, assume it's not going to happen. It's critical that all information is clearly written on those documents. Make sure to get a copy of the documents before you leave. I will move on now to discuss independent educational evaluations. An independent educational evaluation, or IEE, is an important right that SEDMs have if they disagree with the results or adequacy of the district's evaluation. An IEE is additional testing performed by a qualified evaluator who is not employed by the school district. The school district must either agree to pay for the IEE or file for due process against the SEDM to show that their testing was appropriate. We're going to talk in more detail about due process later in this webinar, but it means that the district would be initiating legal action to show that their evaluation was appropriate. An IEE is most appropriate in the situations listed on the slide. So the school's evaluation doesn't accurately reflect the student's skills and deficits, the school's evaluation is incomplete, or the SEDM requests an evaluation and the school refuses to do it. To get an IEE, the SEDM should write a letter to the EC case manager expressing disagreement with the school district's evaluation and requesting an IEE. The SEDM is not required to explain why they disagree. However, that can be in the letter provided to the school. Facilitated IEP meetings are an option provided through the North Carolina Department of Public Instruction, or DPI. DPI provides an impartial facilitator at no cost. The facilitator is not there to make decisions or resolve the dispute. Instead, the purpose of the facilitator is to help guide communication between team members. The most useful time to take advantage of this option is when the relationship between the SEDM and the school is tense. So when the SEDM is not feeling heard by members of the IEP team, or IEP team meetings have not been productive because of strained relationships, or there's a need for real discussion about changes to the IEP. I think we have all experienced a situation in life where a relationship has become so soured that it feels impossible to have a real conversation. SEDMs are already at a disadvantage in IEP meetings. They often feel overwhelmed and outnumbered. If you add on top of that a situation where the SEDM believes they are unliked by school staff in the room, it may feel like there's no way to find a resolution. Bringing a neutral third party in this situation can change the tone of the meeting and help bring the conversation back to what is needed for the student. A facilitated IEP meeting can be requested by the SEDM, by an adult student with a disability, or by a school representative. DPI has a specific form to fill out to request a facilitated IEP meeting that can be found on their website. If there is an IEP meeting already scheduled, you must request a facilitator at least 10 days before the meeting. Both the SEDM and the school district must agree to have a facilitator at the meeting. It's generally a good practice to agree to a facilitated meeting if suggested. It shows an effort to try to work together to resolve the issue. Based on my experience with these meetings, the facilitators like the meetings to be very focused on only a couple issues at hand and have strict time guidelines for the meeting. They are unlikely to address every concern that an SEDM might have, so the time should be devoted to whatever is most pressing. The next avenue is to utilize DPI's dispute resolution consultants. This strategy is underutilized. I've listed the current dispute resolution consultants on the slide, though the DPI website will always have the most updated list. This strategy is best used in a situation where you have questions about the actions the school district is taking, or the school district is violating a procedure and you want it resolved quickly. In my experience, they will contact the school district directly and try to help resolve the problem. There are some important things to be aware of, though. The school district will know that you have contacted DPI. Therefore, be prepared for school staff potentially to become a bit defensive. Second, you cannot file a state complaint or any type of formal complaint through calling them. This would be a way to get some quick clarification from DPI and potentially some assistance in a situation, but would not lead to any sort of formal resolution unless you file a formal complaint. If you end up not liking DPI's advice on the situation, it may indicate how DPI may interpret the situation were you to file a state complaint. It does not necessarily mean that the outcome of the state complaint would not be favorable, because the state complaint, as we will discuss, involves an investigation. But it could provide some useful information about how DPI may likely approach the situation. I want to share a quick scenario when we have suggested using this. There was a student who had significant special education needs and was transitioning back to a North Carolina school district from a psychiatric residential treatment facility out of state. While in that facility, the student's IEP and his eligibility had lapsed. When he enrolled back in the school district stated they were going to treat him as a regular education student without any comparable special education services until they could complete a full evaluation. Now, this student was used to being in a very specialized environment and would have struggled enormously without special education services. This information had come from the district level, so we knew that the SEDM would not get anywhere from working their way up the ladder in the district. The DPI dispute resolution consultant was able to help get this resolved quickly and without the SEDMs having to file a formal complaint. Mediation is a process where a trained neutral mediator helps resolve a dispute between the SEDM and the school district. This is a good option if the IEP team is unable to reach an agreement on an issue such as eligibility, services, or placement. For example, the types of issues that can be mediated include whether a student is eligible for special education, or the amount or type of special education or related services provided, the setting in which the student receives both general education and special education services, and the student's entitlement to compensatory education to make up for a past lack of appropriate services. The mediator does not make decisions or resolve the disagreement themselves. Instead, The mediator helps the parties express their views and understand the position of the other party. Mediation can be requested by the SEDM or the school district. And this is a voluntary process intended to avoid litigation. Neither party can be forced to mediate. DPI provides the mediator at no cost to either party. Mediation is confidential. All conversations about possible settlement of the dispute cannot later be used in a court proceeding. If an agreement is reached, the mediation agreement is legally binding. SEDMs may bring advocates or attorneys to mediation, but need to let the mediator and school district know ahead of time. Mediation can be requested by filling out a form on DPI's website. And we have included a resource in your handouts from the Advocacy Institute and Duke Law School's Children's Law Clinic about preparing for mediation. State complaints are a process to allege that the LEA, Local Educational Agency, has violated a requirement of IDEA. An LEA, like CMS, is a public board of education or other public authority that administers public schools. This includes public school districts, charter schools, and North Carolina psychiatric residential treatment facilities, or PRTFs. A private school is not an LEA and therefore is not required to follow IDEA. So a state complaint can be filed by an SEDM or anyone else. And the timeline is very important here. To allege a violation in a state complaint, the violation must have occurred within the past calendar year. DPI state complaint procedures say that they may accept and resolve complaints regarding allegations of continuous violations outside of the 1-year time limit when extraordinary circumstances exist. One of the main benefits of this process is that the complaints are resolved quite quickly. DPI has 60 days to investigate and resolve the complaint. Here are some examples of issues that would be ripe for a state complaint. The IEP has not been implemented as it was written, or the school district hasn't met the 90-day timeline for initial eligibility. The school exited a student from EC services without first evaluating them, or the school did not hold a manifestation determination review, an MDR, when required. And MDRs are meetings that occur once a student with an IEP has been suspended for more than 10 school days in a school year. These are required meetings, and it would be a violation for a school to fail to hold one within the required timeline. State complaints are best for clear violations of the law. They are not the best avenues for disagreements about what is appropriate for the student, or disagreements over what is the least restrictive environment for a student. For instance, if the SEDM wants their student to be in an inclusion environment, and the school thinks they require a specialized classroom, DPI is not going to weigh in substantively on the decision to resolve the issue. They instead are looking for whether the school district followed all of the procedures required by the law. A state complaint must include a factual description of what occurred, an explanation of the law or policy that was violated, and what the SEDM wants to happen as a result of the complaint. DPI has a form that can be used to file the complaint. In our office, we don't tend to use the form and instead write the information in a detailed letter. It's very helpful if the SEDM attaches written records that show the alleged violation. For instance, if the concern is that the district did not meet their 90-day timeline for initial eligibility, it would be important to include documents such as the initial request for an EC referral and evaluation. In response, the district will provide their own records. It is particularly helpful to include records and documents that the district may not have or may not include in their response, such as emails between you and school staff if they are relevant. We like to emphasize the importance of having things in writing. DPI can't review a phone call. They cannot review what someone promised when you saw them in person. What they will review is what is able to be provided in physical documents. It is critical to get information in writing and keep it in an organized fashion. Once DPI investigates, they will determine if the school followed the law. If the district is found to have been non-compliant, meaning they did not follow a required policy, DPI can require them to complete corrective action. In the complaint, you are suggesting what you want this corrective action to be. Some types of corrective action include remediation or compensatory education. These are one-on-one services designed to put the student in the position they would have been if not for the violation. Changes to district practices if needed, and training for school district staff. State complaint decisions are not appealable. If DPI receives a state complaint, but due process has been filed in the case, they will not investigate the state complaint. It's not possible to do both at the same time. Here are some helpful resources for state complaints. You do not need to be an attorney to file a state complaint. This is intended to be a parent-friendly process. The IDEA State Complaint Resource Center has really helpful information and sample complaints. DPI also has formal state complaint procedures on their website. They include information such as the required components in a state complaint and DPI's intake and investigation processes. It is important to read these closely before filing a state complaint. Lastly, we have due process. Due process is a formal legal process for resolving disputes about special education issues. It can be used to address issues related to eligibility, evaluation, placement, FAPE, or appealing a manifestation determination review. Due process is initiated by filing a contested case petition. This starts a proceeding against the school board. This can result in a settlement agreement or go to a hearing and be decided by an administrative law judge. The due process petition must include the facts that support the case, a statement of what law was violated, and the desired result. These cases are handled by the Office of Administrative Hearings, or OAH. Timing with due process petitions is very important. They must allege a violation or disagreement that occurred not more than 1 year before the date that the SEDM or LEA knew or should have known about the alleged violation or disagreement. A benefit of filing for due process, especially when there is a disagreement about a student's placement, is something called stay put. It means that while the due process petition is being resolved, students will remain in their last agreed upon special education placement. For instance, let's say an IEP team exited a student from EC services, but the SEDM disagrees. If the SEDM files for due process, the student would continue to receive their special education services during the due process proceedings. Once a due process petition is filed, a resolution session must be called by the LEA within 15 days. During the resolution session, the LEA and SEDM may come up with a legally binding agreement to resolve the dispute. Alternatively, the LEA and SEDM may agree to waive the resolution session or choose mediation instead. A resolution session is like a settlement conference. SEDMs are asked to tell the people at the meeting why they filed the due process petition and what they want for their student. School personnel can then respond and everyone can talk about ways to resolve the dispute. Unlike a mediation, discussions at resolution sessions are not confidential. Anything said there can be mentioned in a due process hearing. This should be kept in mind when considering a resolution session. Due process hearings are very formal and follow formal rules of evidence. The SEDM can be represented by an attorney, but not by a non-attorney. While it is not required for SEDMs to have an attorney, It's very difficult for SEDMs to handle a case on their own due to the many court rules that must be followed. Both sides present evidence and confront and cross-examine witnesses. The administrative law judge will determine the facts and conclusions of law and render a decision. The entire process can last for many months. The actual hearing itself can last from a couple of days to a week or longer. If the SEDM is ultimately successful, they can be reimbursed for attorney's fees by the school district, but not for the fees of expert witnesses. Either party can then appeal to state or federal court. I'm going to review this material with a challenge your understanding hypothetical. As I read it, start to think about how you would respond in this situation. It reads, a father got a new job and moved to a new city in the same state. The father has a student with special education needs. However, when the father enrolled his student in the new school district, the new school failed to implement the IEP. What do you suggest the father do to resolve this issue? Let's break this question down a little. The student has moved to a new school district in the same state. So first, you may ask yourself if the new school district is even obligated to implement the IEP that came from another district. The answer is yes. If a student with a disability who has a current IEP that was in effect in a different LEA in the state transfers to a new LEA in the state, the new LEA must provide a FAPE to the student and something called comparable services until the LEA either adopts the student's IEP or develops a new IEP. Comparable services are special education services that are matched as closely as possible to the services the student had been receiving. As an aside, things would be a bit different if the student was transitioning from outside of North Carolina with a current IEP. In that case, the new district must provide a FAPE and comparable services until the new district conducts an evaluation to determine if the student is eligible in North Carolina, and if so, develop a new IEP. So now we know that the new district was supposed to provide comparable services and then hold an IEP meeting to either adopt the IEP or develop a new IEP. From the situation described here, it doesn't sound like the new school has done anything. So let's think about what the father should do first. Make sure that he provides a copy of the IEP to the new school district. Ideally, he should have done that at enrollment. The new school will always request records from the previous school, but it's best practice for families to provide IEP documents at enrollment to make sure that the new school has them in a timely manner. You should contact the top school level people, a principal and EC compliance facilitator, to request that the school immediately begin providing comparable services and to schedule an IEP meeting. You should make sure that all of these requests are in writing and that he is keeping documentation of everything that is happening. Ideally, the father would have requested the IEP meeting to be scheduled quickly once the student was enrolled. This would be a chance to have the IEP team get to know the student and his father and find out more about the structure of special education services at the school. The father also can request compensatory education services to make up for the service time that was lost. So what happens if the school level folks aren't responsive? It would make sense to contact the EC department for the district and seek assistance. Your request would be the same: comparable services, an IEP meeting, and compensatory education. And then what if the district level folks do not give a satisfactory response? So this could be a good opportunity to contact a DPI or dispute resolution consultant to try to get a quick fix so that the student can start receiving services. And what other options might you pursue? A state complaint is probably the best option here. This is a straightforward violation of the required procedure under the law and something that DPI could investigate and address through a state complaint investigation. Mediation is another possibility. But if you've already worked with the district level folks, it may not be as productive. I would prefer DPI giving a clear answer that the district's actions were wrong. And then if we think about what type of corrective action you would want the district to have to do for mistake complaint, finding of noncompliance, that might be compensatory education again, training for school staff, and then for the district to have to review and revise their policies on transfer students if that's needed. I hope the information that I provided has been helpful. As a reminder, please reach out to us if you may need any of our services or want to learn more about them. I've provided here some links to some helpful resources, including the full version of the North Carolina policies governing services for children with disabilities. Also, please be sure to review the handouts for this presentation. Please remember to complete your post-workshop survey. It should only take a couple minutes and will provide us with feedback that we can use to improve our webinars and presentations. Thank you again for watching.